I think that a jail sentence is appropriate in this case. I'm not going to put you on probation. I'm going to leave Polk County to do what Polk County is going to do. And that can be a trial, that can be a dismissal, that could be anything. I don't know those facts, and that's not going to come into the play here. The only reason why I'm doing the prison sentences, quite honestly, all of those things that I've just said, you don't have an address, we wouldn't know how to contact you, you're still in custody in Polk County Jail. I don't know how long it's going to take for you to be released from Polk County Jail. It looks like you're on a high bail. I don't know if that's going to remain. I don't know if it's not. I don't know where that case is going. Again, I don't care about that matter. 26 CT 02, State of Wisconsin versus Kenneth Sowens. The state appears through District Attorney Kevin Schmidt in person. Mr. Sowens appears in person without counsel. We're set today in this matter for a status conference. Mr. Sowens, you were very close to paying off your Minnesota fines and fees, and then that's kind of the hiccup to you being able to be cleared to drive in Wisconsin. Were you able to do that?
No.
All right, so what's the offer?
The offer is to plead to the charge, and the state will argue for 10 days jail. The defendant's free to argue.
All right, so are you accepting that offer, or do you want me to set a jury trial today?
If we set a jury trial, will I be able to take the deal if I decide to later on, or?
Not necessarily, because
Okay.
I will give you a deadline
All right.
of that. If you wish to have a court trial, do you understand the difference? Court trial is you can waive your right to have a jury and you can just argue and have a trial in front of me.
Okay.
With a trial like that, because I don't have to call in 60 or so people
okay, cool.
to do those things. If you do choose to have a court trial, yes, you could then still accept the offer up until that date.
I don't know. I think I'll just take the plea.
Okay, so you want to, but do you want some time, more time to think about it? I know that the offer was out there, I think since January or before. Do you need more time to think about it?
I mean, if that's available.
To give you a little bit more time?
Yeah, that'd be
I
cool.
can do that. And if you want me to set a court trial and not a jury trial, I can do that. So then you can see if you can get on a faster track to get your license.
Okay.
And then it'll give you time to think about if you're not able to get your license, if you wish to accept that deal. And so you can understand though, I'm not bound to follow any agreement that's been reached. I'm not bound to follow any recommendation for 10 days, or did you say it's a free to argue, or he is accepting, or the state can argue for jail?
I'm arguing for 10 days jail. He's free to argue what he wants.
Okay, so you're free to argue what you want, what you think that I should sentence you to. So Mr. Schmidt's offer is plead to the charge. He's going to argue for 10 days of jail. You can make your plea to the court and say, Judge, I understand this, blah, 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 but I think it's more fair if you do blah, 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 blah.
Okay.
Okay?
Mm-hmm.
All right. So you wish for me to set a court trial date? Or do you want to accept the offer?
Court trial date will work.
Well, and that is going to give you a little bit more time. And with a court trial, I would think that we wouldn't need more than an hour. Or do you think 2?
An hour.
I could do Wednesday, August 26th. At 3.
Yeah, that works.
Okay, so then that still gives you a month and a half almost to be able to work harder to get your license. And then if you do wish to accept the offer on that date and time, you can come to court and you can say, you know what, I want to accept that offer and I'd like to move forward and argue for what I think is fair and reasonable.
Okay.
Okay?
Yeah.
August 26th at 3 o'clock. Anything further?
Not from the state.
All right, then we are adjourned. You can come up and get your notice. Thank you.
Thank you.
I have Attorney Lonzo from Gray and Associates, Emily Toms for US Bank National, and David Seinko. Is that how you say your last name, sir?
That works, Your Honor. Hello.
No, is it Seinko then?
We pronounce it Shenko. It's a weird Russian
Shenko.
Polish name. I apologize.
Well, I like to say people's names correctly. And if I don't feel, I'm not offended if people correct me because I want to say it correctly. Shenko.
Yes.
All right. We will go on the record in the matter 25 CV 137 Voyager Village Property Association, Owners Association versus Christopher J. Rudy Trust. Appearances are all by video conferencing. We have Deanne Cole for Voyager Village. We have Greg Miller for the trust. We have Emily Toms for US Bank National. And we have Patricia Lonzo and David Shenko for the loandepot.com. We were set today originally on a motion hearing, but I believe that for a protective order, but the parties have worked that part out. And so everybody was just asking to have a status / scheduling conference, I believe. And Ms. Cole, I believe that was your motion that you filed.
Correct, Your Honor. Thank you. I can update the court that after Attorney Miller got on board for the primary defendant, I worked with all the parties and we currently have a mediation scheduled for August 6th. And so it would be the plaintiff's proposal that we adjourn this scheduling conference to sometime after August 6th. In the event that it isn't resolved at mediation, then we could schedule, put this on a typical scheduling order, but I think it likely doesn't make a lot of sense to do that, given that that's only 2.5 weeks away.
I completely appreciate that. Thank you all for stepping in and trying to see if there could be a potential to work this out. And for the record, I do have Christopher Rudy making an appearance by video conferencing capability, just a tad late, so the court didn't pull him in until just now. That sounds perfectly acceptable to the court. Is there anything else that the court should be updated on, or is that just it?
Nothing more from plaintiff.
So, Your Honor, I'm the newbie in the case, Greg Miller here, and thank you for pronouncing my name correctly. But I didn't see anything, but I presume there is no previous scheduling order in this case. Is that correct?
There is not.
Okay. All right. And the only reason I say that is if we're successful at mediation, then nothing else matters. If we're not successful at mediation, then I may need to amend the pleadings that were originally.
I figured I figured that's where we were most likely going to go.
Right.
And so that is completely, that will be open, and for the most part, the court doesn't, I don't hop in and do a scheduling order until we're in the case a little bit, because things like this happen and a mediation could be successful and we can all move on with our lives and go from there. And so for the most part, unless there's some significant reason why the court shouldn't, I generally do put in as the number one, and parties may amend their pleadings and or other things by such and such a date, and then have other dates after that.
Thank you, Your Honor. Nothing further from defendant Rudy trustee.
All right. Thank you, Mr. Myler. I'm just kidding, Mr. Miller.
Yes.
Okay, anything else from any other party? All right, then we're good to go. Thank you for continuing to try and work together, because we all know in the end, that's better for everybody. But if not, and we have to go to trial, then that is what it is as well. Okay, thank you. I will wait to hear from you. Somebody please update the court as to the mediation after August 6th, if it was successful or not successful, whether or not you asked to have a scheduling conference in that notice to the court. That doesn't matter to me, but I will leave it to the parties. If it's not successful, sometime down the road to contact the court and say, hey, can we please schedule something? Because there's a lot of people to work with and to put on the calendar. So
I'm happy to do that, Your Honor.
thank you, Ms. Cole. All right, then we're adjourned.
Thank you.
Thank you, Your Honor.
Ms. Burhow, I'm going to put both of us into the waiting room until 10:30.
All right, hang on a sec.
No problem. You take your time. We're early, so however long you need.
No, it's okay. I just was working on transcripts.
Because
Every
you-
little bit helps.
Yeah, it does. And I just want to say that I really do appreciate you, Ms. Burhow, and I appreciate all the court reporters that work together. And I'm going to tell you that I do miss Corey because I miss the real time.
Yeah.
But you're great too. And I don't know how any judge could go without a stenographer. I just don't.
Thanks, Judge. I appreciate that at my old ripe age.
All
I'm
right,
ready.
we will go on the record in the matter 26 CM86, 26 TR 259 and 341, State of Wisconsin versus Shelley Kankey. The state appears through District Attorney Kevin Schmidt in person. Ms. Kankey appears in person without counsel. We're set here today in this matter for a status conference. Ms. Kankey was provided an offer from the state to plead to the OWI first, lowest guidelines, and then to dismiss and read in the criminal matter as well as the other ticket. Ms. Kankey, have you had enough time to think about this offer?
Yes, ma'am,
And do you wish to accept the offer?
I do.
Okay, and so we're doing a formal motion, Mr. Schmidt, to amend the BAC from 0.25 down to 0.09.
Yes, Your Honor.
All right, that is granted. As it relates to the OWI first, Ms. Kankey, we did go over that previously, that this is not a crime, it's a ticket. And so it will have a certain amount of court costs and fees and those kinds of things. The other matters will go away and be dismissed and read in. And you would have the right to go to a trial. You'd have the right to have an attorney if you wish to, but not a court-appointed attorney or a public defender because it's a ticket. You would have the right to have a jury of 6 of your peers, but only 5 of the 6 would need to reach a decision. Only 5 of the 6 would have to have the same decision. And you would have the right to have the state prove your guilt by what's called reasonable certainty. So do you understand?
Yes, ma'am.
And you wish to waive those rights?
Yes, ma'am.
And you wish to enter a guilty plea for an operating while intoxicated first offense?
Yes, ma'am.
Are you admitting here today that you are guilty of that offense?
Yes, ma'am.
And so you're accepting responsibility and accountability for that?
Yes, ma'am.
Do you have any questions for the court or for Mr. Schmidt before we proceed?
I don't think so, but somebody had told me, you got to go to counseling or whatever for
Yes.
that. I was wondering, I am in counseling and seeing a therapist.
It's a different thing, and I can answer that for you right now. Because with an OWI, first or otherwise, the court has to order that you go to someplace like Aurora. It has to be within your own county. So they can do an OWI AODA assessment.
Okay.
And then in that assessment, they'll tell you, well, you need to have 3 alcohol and other drug therapy sessions. So it's different between just going to a therapist and talking about your daily life and how it's affecting you and these things. This is specifically focused on alcohol and other drugs.
Okay.
Okay?
Yep.
And so, yes, you will have to do that. I don't know if, do you go to Aurora?
No, I go to SOAR.
Okay. And I'm not sure, I think you have to do your AODA assessment here, OWI assessment here. You'll get it on the order. Our clerk over here, she is great at getting all of the information. And if you have any questions, you can just call up to the clerk's office, ask for Amy. She's our guru as it relates to OWIs and things of that nature, okay? So any other question?
No, ma'am.
All right, then as to 26 TR 259 OWI first, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. You are pleading guilty, so the court will accept your plea of guilt. The court is going to dismiss and merge in 26 TR 341 with the other ticket, the OWI first. And I'm going to dismiss and read in 26 CM 86, the misdemeanor. A judgment of conviction will be entered. This is the lowest guideline. So what the court is going to do is follow that $936.50 plus a $10 blood draw fee, 6 months of revocation of your driver's license. But I will give you credit for any administrative suspension you have already received, okay? And I'm gonna order the OWI AODA assessment and all of the follow through, which would be a driver safety plan and any sessions that they say that you need to complete, okay? You do not need an ignition interlock device because this was amended down to a lower blood alcohol content, so
Okay.
you're good to go with that. I think that covers everything, Mr. Schmidt.
That's all.
Anything else you want to
No,
add?
ma'am.
Okay, then what the court is going to need you to do is come either here, or do you want her to go out there to you? Do you give her the orders now or you mail them?
I can mail them, or we do have some of the OWI assessment information out front.
Okay, so what we can do, and we're swapping right now. You can go out front, go talk to Amy out front, and then she'll give you some information. She'll mail the rest of the actual court documents to you, but she can give you information on that assessment and those types of things, okay?
Okay.
All right, then we are adjourned. Thank you.
Okay. Thank you, Yana.
Oh, wait, I guess. When are you able to pay that $946.50?
Can I make payments on it?
You surely can. Are you employed?
I'm not. I'm on Social Security
How
now.
much do you get a month?
1,196.
And how much is your rent?
313,
$313. And how much is your phone?
40.
Okay. And any other huge expenses monthly
Besides food.
besides food?
Well, internet, I don't know if that's considered.
All right, what the court is gonna do is I'm gonna order $100 a month. Okay, so make sure that you pay $100 a month. The first payment I can give you to start in August.
Okay.
So give you a little bit of time and then $100 a month thereafter. If you fail to make a payment, not only will the court enter a civil judgment against you, but you won't be able to get your driver's license back. And the court will issue a warrant, okay?
Okay. I can pay more. I have change I was gonna cash in and,
You can pay more, great, but I
Okay.
want to make it financially feasible for
Right.
you. I don't want to take house and home and food and those things, okay,
Sure.
away from you. So I'm comfortable with $100 a month, but the sooner you want to get the court off of your back means pay it faster,
okay.
okay?
Yep.
All right, thank you, then
Thank
we are
you.
adjourned. Okay. Mr. Jacobson, can you hear me? I can't hear or see you. Ms. Burhow, you can hear?
I can.
Thank you. There we go.
Sorry about that. It's really slow.
Nope, that's a-okay. We're still early, but we don't need to worry about victims in this matter. Just want to make sure. We will go on the record in the matter 26 CF 85, State of Wisconsin versus Tyler Jacobson. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Joel Feliski, Defense Counsel, in person. Mr. Jacobson appears by video conferencing from the Polk County Jail. We were set here today for a speedy preliminary hearing. However, through the course of negotiation and discussion with his client, Mr. Feliski was able to inform the court that the matter is resolved and that the defendant will be entering a guilty plea in this case, I believe, to methamphetamine. I think you filed a plea questionnaire.
That is correct, Your Honor. And my understanding of the agreement would be for Mr. Jacobson, contingent on waiver of the preliminary hearing, to plead to count 1 and 26 CF 85, which would be the possession of meth charge, with the remaining counts being dismissed and read in, with a joint recommendation between the parties for withheld sentence, 18 months of probation, along with court costs and fees. I've reviewed the terms of this proposed offer with Mr. Jacobson, Your Honor, and I believe he is interested and is going to be accepting that offer. I've gone through and reviewed a waiver of a preliminary hearing form with Mr. Jacobson that's been filed with the court and has been signed as document 19. I've also reviewed and completed a plea questionnaire form with him, Your Honor, that's been filed as document 20.
All right. Okay. Mr. Jacobson, you are appearing by video conferencing. Do you understand you have the right to be here in person?
Yes, ma'am. Yes, Your Honor.
Okay. Do you understand that at any time, if you have any questions or concerns and you need to speak with your attorney, just let me know. I can send him into Zoom and you can have a confidential breakout session.
Yes, Your Honor.
Okay. And so you're waiving your right to be here in person?
That's correct.
Oh, that sounds good. All right, I do have in front of me a plea questionnaire waiver of rights form. It is filed electronically, and it does have your signature. Is that correct?
Yes, Your Honor.
Okay. Now, did your attorney go over that document with you?
Yes.
And do you understand it completely?
Yes.
Now, Mr. Jacobson, you're pleading guilty to a felony possession of methamphetamine. Is that correct?
Yes.
And you understand you would have the right to have what's called a preliminary hearing.
Yes.
Did your attorney go over with you what that means?
Yes.
Do you understand the burden is on the state to prove a felony was probably committed by you in Burnett County?
Yes.
Do you understand that by waiving your right to a preliminary hearing, it means that you agree the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses to testify for you. He'd be able to produce evidence on your behalf or possibly discover defenses throughout that hearing. Do you understand that by waiving your right, you're giving up those rights here today?
Yes.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or promises to you other than the offer presented for you to waive your right to a preliminary hearing?
No.
And you're doing so freely, intelligently, and voluntarily?
Yes.
And you understand that once you give up the right, it is forever?
Yes.
So you are pleading, the proposed thing for today is you'd be pleading guilty to count 1, possession of methamphetamine, correct?
Yes.
Mr. Schmidt, do you have an information to file?
I can do that.
All right, and information is going to be filed and it's going to mirror the criminal complaint. Mr. Feliski, we're going to at this time enter not guilty pleas, at least at this time, to all of the counts. And then we'll proceed to make sure that this is what Mr. Jacobson wishes to do. So Mr. Jacobson, do you wish to accept the offer as stated on the record of plea to possession of methamphetamine, withheld sentence, as well as court costs and fees?
Yes.
And do you understand that that is an offer from the state and the court is not bound to follow that offer?
Yes.
And you still wish to proceed and enter a guilty plea?
Yes.
You're 36 years old. You have 12 years of schooling. You can read, write. You understand the English language.
Yes.
You are receiving treatment for a mental illness or disorder. And would that be AODA or other disorders? What is it?
Other anxiety, depression, PTSD, ADHD.
And are you taking medications for those?
Yes.
And have you taken them as prescribed?
Yes.
And so on the plea questionnaire, it says that you haven't had any alcohol, medications, or other drugs in 24 hours, but you have, as given to you by the jail, for those conditions.
Yes.
Now, do those medications interfere with your ability to understand or comprehend anything?
No.
Do they actually put you in a position where you can better understand and comprehend?
Yes.
Do you understand that by pleading guilty, you're going to be waiving your constitutional rights?
Yes.
Did your attorney thoroughly go over your constitutional rights with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that the state would have to prove on or around June 11th, 2026 in Burnett County, Wisconsin, that you possessed a substance, the substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine? Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
Yes.
And do you understand you're pleading guilty as a party to a crime? Do you understand what it means to be a party to a crime?
Yes.
You either directly committed the crime yourself, you aided and abetted someone else who was committing the crime, or you conspired with one or more persons to commit a crime and affirmative steps were taken towards that commission of the crime. So you understand what that means?
Yes.
Do you understand that there is an agreement here for withheld sentence and for court costs and fees, but I'm not bound to follow that?
Yes.
Do you understand I could sentence you all the way to the maximum penalty if I thought it was warranted, or I can do an imposed but stayed sentence, or I can sentence you to anything that I feel is an appropriate sentence?
Yes.
Do you still wish to continue and enter a guilty plea?
Yes.
Do you have any questions for your attorney or for the court before I proceed?
No, Your Honor.
Did you go over the criminal complaint with your attorney? That is that original charging document where it says basically what happened that day and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did possess methamphetamine?
Yes.
Are you pleading guilty to the crime because you are guilty?
Yes.
Mr. Feliski, may the court use the probable cause section along with the statements made by your client to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Jacobson, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you the evidence in this case?
Yes.
Has he discussed with you whether or not you have any legal defenses or a lack of defenses in this case?
Yes.
Have you discussed with him all facts that you know to exist about this case, including any co-defendants, any alibi, any third-party information?
Yes,
Are you satisfied with his services?
yes.
Any questions for the court or for your attorney before I proceed?
I had a bond of $250. I was hoping that could go towards the fines that I owe.
It will. You are so, thank you for saying that, but yes, that is exactly what would happen.
I appreciate you.
Anything else?
That'll be all.
As to count 1, possession of methamphetamine as a party to a crime, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Counts 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Simple possession is not a crime of moral turpitude. It's a crime of addiction. The court should start with probation first on any sentence. I think probation is appropriate here. Thank you.
Thank you, Mr. Felisky.
Thank you, Your Honor. I concur with the remarks made by the state. I do think that probation is appropriate here to deter future behavior and ensure compliance, along with providing resources to address the underlying issue here, which would presumably be, given the nature of the charge, substance use. Overall, I do think this is an appropriate agreement. I'd ask the court to follow it. Thank you.
Is he currently on any types of probation?
Your Honor, I believe he is currently on probation. I believe that is out of Polk County. Oh,
Just in county jail at the moment. Sorry.
oh, I see. I stand corrected then.
You're not on any probation?
No, ma'am. No, Your Honor.
Okay. Thank you. So nothing else that you want to add?
Not at this time. Thank you.
Okay. Mr. Jacobson, any statement you want to make? Anything you want to tell me, you want me to be aware of and need to know?
I'm seeking help. You know, I've dealt with addiction most of my life. I am accepted into the Salvation Army Treatment Center in Minneapolis, which I hope to be. I hope that's the direction I'm able to go to from here.
All right. Thank you, Mr. Jacobson. In this case, before this court, I am aware of Polk County case number 26 CF 232, where you have far bigger fish to fry. I'm taking notice of that, not as it relates to this sentence. I can't even use that with regards to the sentence, just that I'm aware of that case, and that is why you are in custody right now. I wasn't sure if you were in probation on any other matters. Are you originally from Wisconsin?
Yeah, I was born in Frederick, raised in Danbury.
Okay, and so, well, wow, I don't think, have I seen you? You don't look familiar to me.
A couple years ago, you imposed a $1,000 fine, so I owe a little money left on that.
So what is your criminal history?
Addiction, mostly possession, 5th degree possessions of meth, and fleeing a police officer.
Oh, it was more than a couple years ago. It was 2019.
Yeah.
That was a while ago. That's why I don't recognize you. And you have only been in front of me for that case. Now this case. Okay, so in this case, and looking at this case only, with what you've had in front of this court previously, this isn't a case where it was significant or substantial. Obviously, it wasn't, because I only placed you on $250 cash. It was a small amount of methamphetamine and THC, or the illegal substances. So it was a small amount. And you don't have a significant history, at least in front of this county. So your name, your face didn't light up in my brain that I should have been more concerned about the public or the need to protect the public. it sounds like you do need some help and that probation is a place to start with getting that help, at least again, in this case and for this court looking at the facts of this case alone. And taking into account that 2019 matter that was in front of this court. What is your address?
I don't have one at the moment.
Was it Balsam Lake? Because that's what we have.
No,
Oh, no, we have Little Canada.
but that was my old address, where my sister used to live.
But you don't have an address, so you don't have a county in which you live in or reside?
Not at the moment. I was just released from, North Dakota State Prison, March 3rd.
What was your prison sentence for?
Possession of meth.
Simple possession or intent to
No.
deliver or deal?
Intent
Intent?
to deliver.
So you
yeah.
were convicted of intent in North Dakota?
Yeah.
What was the amount of methamphetamine that you had in North Dakota?
26 grams.
26 grams? And that was the actual weight from the lab?
26.6 or 7.
All right, so here's the deal. Now knowing all of that, because that is something that I can consider going into this matter. Do you need probation? Probably. You probably need some help guiding you and doing some things. I'm gonna guess you're on some type of parole or extended supervision, something out of North Dakota. You have to be if you were just released. You're not?
No, I expired my time. I sat the whole time.
Okay, well, that makes sense too. Get her done. He doesn't have an address, so even if he is released from Polk, I have no idea where he's gonna be. So that's gonna be difficult on probation to even, provide services or to meet with him and do those things. So in this case, even with that and taking into the North Dakota, prison matter, I don't think a probation is appropriate, but this is not a prison case here. You're in custody in Polk County for, I don't know how long, I don't know what you're doing. Do you still have connection with Burnett County?
Yeah, there's my boss lives in Burnett County, yeah.
I'm sorry, you cut out a little bit. So if you cut out for me, you cut out for our court reporter too.
I said, yeah, my mom and my stepdad live in Burnett County. Shauna Hagan, Ted Hagan, they own a ranch up there, Sky High Ranch.
Okay. The last time you were in front of this court, 2019, not a serious matter, resulted in a fine. I think that a jail sentence is appropriate in this case. I'm not going to put you on probation. I'm going to leave Polk County to do what Polk County is going to do. And that can be a trial, that can be a dismissal, that could be anything. I don't know those facts, and that's not going to come into the play here. The only reason why I'm doing the prison sentences, quite honestly, all of those things that I've just said, you don't have an address, we wouldn't know how to contact you, you're still in custody in Polk County Jail. I don't know how long it's going to take for you to be released from Polk County Jail. It looks like you're on a high bail. I don't know if that's going to remain. I don't know if it's not. I don't know where that case is going. Again, I don't care about that matter. The North Dakota State or the North Dakota case is what I'm looking at in front of me in this court. So what I am going to do is I'm going to sentence you to 6 months of jail, $250 for DNA surcharge. I am going to dismiss all other costs and fees. I'm going to tell you that I'm not going to do this consecutive. You already have, I believe, a month. So you're going to have a few more months to sit. But anytime that you may get, if you do at all, in Polk County is going to be, well, actually, I'm going to amend it to 4 months because this isn't that serious. So for what, Mr. Jacobson?
It's a thank you, Your Honor.
It's just in the case in front of me, it's not that serious with taking into account in North Dakota, it's serious enough for jail and not probation with the other factors. So 4 months, it can be concurrent. There's nothing in me that says it should be consecutive to any sentence he gets later on or anything like that. You have $250 paid, so you're good to go. All fines and fees in my mind are paid because I've waived the rest. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You're going to need to talk to Polk County Jail or Burnett. I'm sure that you can get it to Burnett County for your DNA. In this case, I believe you would have the ability to request it be expunged through a written letter to the Department of Justice. Mr. Feliski can help you through that if that's what you wish to do. Again, 20 days to appeal, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. What am I missing, Mr. Schmidt?
Nothing from me.
Mr. Feliski?
I don't believe anything. Thank you.
All right. Thank you, Mr. Jacobson. Good luck in your other matter. Is there anything else that you would like me to know?
That would be all, other than I'm accepted to Salvation Army, which is a 180-day program minimum. There's open bed.
I hope that you're able to get some treatment and do that thing, Mr. Jacobson, because I truly do believe that you need some type of treatment, hopefully residential, and that could help you along the way. Thank you, Mr. Jacobson. We're adjourned. Ms. Landgraf, can you hear me? Mr. Martinez, there's Mr. Martinez. Mr. Martinez, can you hear me?
Yes, Your Honor.
Okay, and I can hear you. I need to pull up that matter. We will go on the record in the matter 21 CF 152. State of Wisconsin versus Francisco Martinez. The state appears through District Attorney Kevin Schmidt in person. The court has Francisco Martinez appearing from Reno, Nevada jail, I believe, not prison. And we have Renee Landgraf, his defense counsel, by video as well. And is it a jail or is it a prison?
The jail.
Okay, so you're appearing in jail from Reno, Nevada. Do you understand, Mr. Martinez, that the court could wait and you could be here in person to handle all of these things?
Yeah.
And you're appearing by video conferencing. Are you asking the court to allow you to appear by video, even if this is a sentencing hearing?
Yes.
And if you have any questions or concerns and you need to speak with your attorney, she's by video as well, so I can send you into a confidential Zoom room hearing or breakout session. Do you understand that?
Yes.
Ms. Landgraf, are we proceeding with the sentencing hearing?
Yes, Judge, we would like to proceed with sentencing. I did talk to the DA a little bit this morning, and I believe that he's on board as well.
All right, so. And this is 21 CF 152. And we had a deferred judgment of conviction document, or not document, sorry, I got a note, a Teams quick thing that said document. Deferred judgment of agreement, and he was sentenced in the other cases, or the other case. All right, so Mr. Schmidt, argument and sentencing recommendation?
I think this is a case that should be viewed as simple possession. As the court recalls, this was originally mistakenly charged as possession with intent because there was this methamphetamine on the floorboard that got urinated on and the police just kind of threw it out. I think that he's already in Nevada. This morning, Attorney Landgraf indicated to me that they sentenced him to 18 to 48 months. So I think doing a year county jail concurrent to that is sufficient to appreciate this. It does not make sense to do order probation on somebody living in Nevada who is serving a prison sentence that will be 18 months. Thank you.
All right. Before I proceed with an argument from Ms. Landgraf, Mr. Martinez, do you reside in Nevada?
Yeah,
And so you've moved from Webster, Wisconsin to Reno or somewhere around there?
yes.
Can I get an address of where you do reside?
So I was on 1370 Evelyn Way in Reno, Nevada. But by the time I get released, I'm not sure what my address
Mr.
was.
Martinez, just give her the address for the jail there. Your Honor, he is going to be sent to a prison. He just got sentenced last week, so I anticipate they
yeah.
will probably move him. But if you want to give him the address, give her the address to the jail, that's probably going to be sufficient for the JLC to go get delivered to.
That certainly will be sufficient. Thank you.
911 Par Boulevard, Reno, Nevada.
PAR as in PAR or PARR?
PARR.
Okay, Boulevard, Reno, Nevada. All right. Is there it looks like you turn and you're talking to somebody who's there. Is there a telephone number of somebody if the court needs to get a hold of somebody to set some date or do something? Is there a telephone number for that jail, at least right now?
Not that I'm aware of. I mean, their
Okay, that's something.
phone number should be online though.
Okay, that's fine. Thank you. Okay, now, when you are released from prison in Nevada, is it your intention to reside and stay in Nevada?
Yeah.
Okay. All right, Ms. Landgraf?
Thank you, Your Honor. As discussed, my client was sentenced. I had a little bit difficult time understanding exactly what it was, but I was able to speak with his Nevada attorney before this Zoom call, and the sentence is 60 months. 18 to 48 months is like the initial confinement portion. If released after 18 months, he's eligible for parole at that time. Regardless, he'll be on supervision for 60 months. So depending on how well he does on parole will depend on whether or not he's going to get sent back to be incarcerated. So for sure, for 5 months, he's going to be on supervision. I believe he has credit for 130 days already. He was arrested in Nevada on March 19th. He was sentenced there last week, July 9th, I believe. That's 113 days. And then he had 17 days from when he was arrested. He was arrested on May 17th, 2021 in this case. And then he was on a signature bond on June 2nd, 2021. So I believe 130 days, which is a little over 4 months. We're asking the court to sentence him to 5 months in the county jail. So I think with good time that would be time served. Again, I concur with the DA that additional incarceration or probation is really a moot point at this point, given his sentence in Nevada. I do believe that this was his first felony conviction. Obviously, he got a felony conviction last week in Nevada, but he was offered the deferred agreement here because he had not had a prior felony conviction. So although he's in prison now, at the time of this, he did not have a prior felony conviction. Thank you.
All right, thank you. Mr. Martinez, is there anything you would like to say you want the court to be aware of?
I think my attorney pretty much covered everything.
All right. Well, I do remember the facts of this case and how it originally was charged with intent to deliver and all of the underlying facts of why the agreement was reached and how it was reached. The fact that you were sentenced in Nevada for, is it intent to deliver there? For a prison sentence. Honestly, if the court doesn't, I'm sorry, what?
It was possession with intent.
Yeah, possession with intent. So you're going to prison, essentially, it really doesn't make any difference what the court orders as long as it's concurrent. It doesn't add more time. I think this is serious enough, and in looking at the conviction that you just had and sentencing in Nevada, I think 1 year jail time concurrent with your jail time your prison time that you will be sitting right now. I did quash the warrant as of today, so the warrant is quashed, so it would start now, plus 130 days of jail credit. You would get good time essentially with this jail anyway, but you should be released in plenty of time, and this won't necessarily impact that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. You're going to need to make sure that we have your DNA. Just talk to somebody in Nevada. I'm sure that they can send your DNA to Burnett County Sheriff Department. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. The court is going to order $250 cash for the DNA surcharge. I'm waiving the rest of the court costs. It sounds like you're not going to have the ability to make payment for a significant amount of time. Just so you know, if you fail to pay, the court will issue a warrant and you could sit up to 6 months in jail. Plus the court could issue a civil judgment against you because you're always going to owe that. I believe that covers everything. Mr. Schmidt, what am I missing?
Nothing for me.
Ms. Landgraf?
No, Your Honor, but I just want to thank Attorney Sharp. I believe she's there in the jail with him and using her laptop to allow him to do this Zoom. So thank you to her.
Well, thank you, Attorney Sharp. I do thank you as well. This means that we can wrap up our Burnett County case and he's good to go. All right, thank you. We are
Thank you,
adjourned.
Donna.
Thank you.
Mr. Matrius, you can come on up. 130 days jail. And full time. Yeah. Oh, no, because I sent some to one here in jail. He gets 130 days in jail. Well, and the son. So let me know when you're ready. We will go on the record in the matter 24 CT 107, State of Wisconsin versus Kurt Matrius. The state appears through District Attorney Kevin Schmidt in person. Mr. Matrius appears in person without counsel. We're set today in this matter for a status conference. Mr. Matrius, you have been provided an offer.
I got it.
Yes. What?
I got my permit.
You got your permit? Excellent. Show Mr. Schmidt and we'll see if that is satisfactory.
I just have to go back up and take the eye test because I lost my glasses already.
This is not the permit.
No, she just signed it. She said I passed, but she said I have to go back and take my eye test.
He
Right,
lost his glass.
this is just the driver's license application. There will be a different document you get that'll be.
You have to get that document and then you give that document to Mr. Schmidt.
Okay,
So,
I passed it though.
so when are you gonna go up? I know, I'm proud of you. I can't wait to see your actual permit. So
Yeah.
how long is it gonna take you to get glasses?
I'm gonna try everything this week to get done.
Good, because I'm going to not give you too long. I'm gonna schedule you for July 23rd at 10 o'clock, July 23rd at 10. If you get your permit before then and all's good to go, just bring it to Mr. Schmidt and you most likely won't need to come back.
Okay.
Okay, so
Okay.
hopefully you can get your glasses, take your eye test and we're good to go.
Okay,
You
thank
can
you.
come get your notice and we're free to leave. Thank you, Ms. Burhow. We'll be back on at 1.
See you then, Judge.
Good morning, Becky. How are you?
I'm good. Good morning. Good to be here.
It's a pleasure to have you. I appreciate it. Thank you for
you.
filling in for Corey.
Yeah, I volunteered.
We will go on the record in the matter 26 CF 21, State of Wisconsin versus Megan Kurkowski. The state appears through District Attorney Kevin Schmidt in person. We do have Renee Landgraf, Defense Counsel, in person with Ms. Kurkowski. We're set today in this matter for an evidentiary hearing. Ms. Landgraf did file a motion to suppress evidence. Are we ready to proceed? Yes. Then Mr. Schmidt, can you please call your first witness?
I call Bailey Mangan.
Deputy Mangan, please raise your right hand. You'll be sworn in and come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
All right, you may begin as soon as he's seated.
Could you state your name, spelling your first and last name for the record?
Yes, my first name is Bailey. My last name is Mangan. My first name is spelled Bailey. My last name is Mangan, Mangen.
What do you do for a living?
I am employed at the Burnett County Sheriff's Office as a Sheriff's Patrol Deputy.
How long have you been so employed?
Been full-time with Burnett County Sheriff's Office since December of 2019.
How many total years law enforcement experience do you have?
I started in Siren part-time in February of 2019.
So you've completed the requisite trainings for all law enforcement officers in Wisconsin,
Yes,
and you passed that.
yes,
You've gotten specific training on drug and other interdiction.
yes.
On February 26, 2026, did you meet with a confidential informant?
I met with a source of information, yes.
Okay. Did that informant give you any information about a subject named Hawaiian Eddie?
Yes.
What'd they tell you?
During my contact with that source of information, they provided information about a male who they used a nickname of Hawaiian Eddie. That source provided information that that male was selling firearms or guns. They also used the term dabbling in other things as well.
Did she observe any of these gun sales?
They did observe the gun, yes.
What did she say about a gun she saw?
The source of information stated that they had been at a residence and observed a handgun and had also seen the handgun, and also spoke to the person who purchased the handgun as well.
Did the source say who sold the handgun?
Yes, the source indicated that the male that she described as used the nickname Hawaiian Eddie sold the handgun to Brian Nelson.
And did this person say how much the gun was sold for?
The person provided information that the gun was sold for $150.
Did the sale include ammunition?
Yes.
Was the firearm operable?
The source indicated that they observed or they had seen the gun be fired after it was sold.
How were you able to figure out who Hawaiian Eddie was?
I had shown the source of information a photo of Edwin Akana during my contact with them.
Did they confirm that photo was Hawaiian Eddie?
Yes.
Why did you think to show a photo of Edwin Akana with that description of Hawaiian Eddie?
I had known from previous contacts that Mr. Akana had a long middle name that I guess in my opinion could be construed as Hawaiian.
Did this meeting with this source elucidate information about other issues not related to Edwin Akana?
Yes, several other topics were discussed.
And was the information about other topics accurate?
Yes, I was able to corroborate based off my own knowledge and experience, as well as contacts with individuals and situations that source of information provided about that the information provided in those other accounts was accurate.
Information about drug interdiction in the county?
Drug activity, yes.
Okay. And what did you do after you got that information?
I did some, I guess, checks. I confirmed that Mr. Akana was on active supervision or active probation out of the state of Wisconsin for felony-related drug charges. I also, in that same check, confirmed what I had already known or had already known about, that Mr. Akana was living with Megan Kurkowski on Alden Road in the village of Siren.
I guess before I move on too quick, did the source say when this gun sale happened?
Yes, they described the gun sale happening about a week prior to my contact with the source.
Okay. So after you confirmed the address with DOC and the type of supervision, what'd you do next?
It was later in the day, I responded to the residents on Alden Road.
So the same day you got the information from the source.
Yes.
What'd you do when you got there?
I attempted to make contact with Mr. Kana at the front door of the residence. At the front door of the residence, I actually made contact with Ms. Kurkowski.
Did Ms. Kurkowski, what did you talk about with Ms. Kurkowski?
I explained the, I guess, basic reason why I was there and that I was looking to speak with Mr. Akana. I told her that I knew that Mr. Akana was living there. Ms. Kurkowski said that Mr. Akana was not at the residence at the time, but was at work, but that she assumed or knew that he was coming home soon.
So she confirmed he resided there.
Yes.
Did she say whether she knew what he was on probation for?
I don't recall if she said she knew what he was on probation for.
Okay. Did you speak with Edwin Akana prior to going inside the house?
I did, yes.
Did he confirm that he resided there?
Yes.
Okay. Did you enter the house prior to getting a search warrant?
Yes.
What observations did you make of police interest on this entry into the house?
During the first entry into the house, Ms. Kurkowski, I asked her if she could walk me through the house. I had been in other units, but I don't recall ever being in that specific unit. Ms. Kurkowski walked me into the house back towards the bedroom area. In one of the bedrooms that was identified as the bedroom belonging to Ms. Kurkowski and Mr. Akana, I observed a glass bong or glass bubble pipe bong in the closet, as well as a rubber hose hanging on the, like, I guess, dresser mirror thing on the wall. I guess I don't know how to describe it, but.
And based on your training experience, why were these items of police interest?
Both of those items are consistent with items that are commonly used to smoke or consume or inhale methamphetamine or other illicit drugs.
You said this room was identified as both Edwin and Megan's. How?
Miss Kurkowski indicated that that was their room, as well as on the door, there was some sort of like lettering that indicated that it was Mr. Akana and Miss Kurkowski's bedroom.
Okay. Did you observe anything else on this first search prior to the search warrant?
I don't believe I did.
Okay. And then afterwards, you obtained a search warrant?
Yes.
Where you used this information?
Yes.
And it was of the same residence?
The search warrant?
Yes.
Yes.
Well, one more thing I wanted to dial back to when you got the information from the source. Did she say that Edwin Akana only did this one sale?
The source provided information that Mr. Akana, or Hawaiian Eddie at that time, sold guns, is what the information was.
Was there a specific time he would come around?
Yes, the source indicated that Mr. Akana frequented Mr. Nelson's house on Jamesway Road in the morning hours, around 10-ish.
Okay. I think I already asked this, but this was all done the same day. You got this information from the source and then you did the search.
Yes.
Okay. No other questions.
Thank you, Ms. Landgraf.
Thank you, Your Honor. Deputy Mangan, you mentioned the name Nelson, and that is the person that allegedly bought the firearm from Hawaiian Eddie?
That would be his last name, yes.
Okay. Did you speak with Mr. Nelson?
Not prior to this contact, no.
Why not?
I guess I don't have a reason.
Did you have any other corroborating evidence, text messages, pictures, anything other than the source of information telling you this?
About the firearm specifically?
Yes.
No, I did not.
So you spoke with your source, and then based on nothing else, you went to search his residence.
Yes.
And what were you looking for
for this Act 79 search?
Yes, with the sources information that Mr. Akana, or again, I should say Hawaiian Eddie, because he wasn't identified at that point, but that he sold guns was the information that the source provided.
And did the source say anything about selling firearms out of his residence?
No.
Did the source say anything that my client would have been involved in any way?
There was no mention of Ms. Kurkowski in the actual firearm sale, no.
And you had searched Mr. Akana's vehicle prior to going in the house?
I don't believe we searched the vehicle. I know that he offered consent. I don't recall if the vehicle was searched prior to going in the house, but he was adamant that he offered consent to search his vehicle.
And there were no firearms located?
Correct.
Nothing further.
Redirect.
No.
Right, may step down.
Thank you.
Any witnesses, any further witnesses? I see none.
Not from the state.
Any witnesses, Ms. Landgraf?
No, Your Honor.
All right, Mr. Schmidt, argument.
I have kind of a tiered argument here, so I'll start first with the first layer. So for Act 79, the standard is reasonable suspicion. That is all that's needed. Deputy Mangan had reasonable suspicion. He had a source who he testified to gave him accurate corroborating information on other similar cases, showing her trustworthiness and reliability. And she gave information about a gun sale that was very specific. She described multiple people who were there, seeing the gun sale, how much money changed hand, that he sells multiple guns. This was enough information for Deputy Mangan to have reasonable suspicion Edwin Akana sold a gun, and furthermore, that he had done so multiple times. It is reasonable to conclude that firearms or ammunition might be stored at where you live if you have to put it somewhere if you're selling more than one. The specific information also included information that ammunition went along with it. Furthermore, the remedy being asked for suppression isn't merited here because it doesn't show a violation of a constitutional right. If the argument is that the probationer, the police didn't have sufficient to search the probationer's residence, that argument must fail because for suppression, it has to be a violation of a constitutional right. We know that Act 79 doesn't articulate a constitutional right. It articulates a regulatory framework. So historical argument, prior to Act 79 being passed, DOC always had the ability to search probationers' residences. It was always based on reasonable suspicion. Eventually that went up to the United States Supreme Court in Griffin v. Wisconsin, which I should give a cite to. 483 U.S. 868, 1987. There, the United States Supreme Court commented that probationers enjoy less degree of constitutional protection. They have less of an expectation of privacy because there's a very compelling state interest in having a watch over probationers. Subsequently, the United States Supreme Court in U.S. v. Knights 534 U.S. 112, year 2001, as well as in Sampson v. California 547 U.S. 843 in year 2006, would subsequently hold that even when a court or a law allows search of probationers for any reason at all, even if you don't have reasonable suspicion, it does not violate the Constitution. They just don't enjoy that right. In Wisconsin, we don't have any cases yet on point about Act 79 involving probationer living with non-probationer. What we do have is prior to the Act 79 regime, back when parole was the regime, we have a case about that. That was State v. West 185 Wist.2E 68, year 1994. in which our Supreme Court held that searches of parolees' residences over the objection of a non-parolee living in the apartment are constitutional and do not result in suppression. They said that that to hold otherwise would effectively eviscerate the ability to search parolees at all, because they could just live with a non-parolee. The court even went further and said that even if procedural requirements of the search warrant are not met, this does not automatically result in justifying the exclusion of resulting evidence. They said suppression of evidence must come as a result of a constitutional requirement, not a procedural one, and that not every procedure embodies a constitutional requirement. Which brings me to one of the things listed in the defendant's motion is they argued the search was arbitrary. It was not. The court heard the specific information. Deputy Mangan acted on it immediately. Even if the court held that it was arbitrary or capricious or harassing as the statute prohibits, that would not be a basis to suppress based on State v. West. Those are not constitutional requirements. In fact, you don't really see those terms in the suppression jurisprudence. You see those more in the lawsuit against the police jurisprudence, which is why Act 79 didn't include a remedy of suppression for a violation of those requirements. So to sum up, the state's argument is there's obviously reasonable suspicion. It was recent specific information from a source that also had other corroborated information. They acted on the same day, which shows it wasn't arbitrary or harassing or capricious. It was acting on information from a source. The remedy of suppression isn't appropriate here unless if the court finds that constitutional right was violated, and based on what's been adduced, that isn't the case because it heard that Edwin Akana is a probationer. He was definitely residing there. Probationers just don't enjoy those rights. The arbitrary, capricious harassing, that didn't happen. It wasn't done in such a manner. In fact, the court heard Megan Kurkowski led Deputy Mangan through, showed him the space. It was a shared space even between Edwin Akana and Megan Kurkowski where the evidence was found. Nothing arbitrary, capricious, or harassing about that. If anything, it was pretty friendly. Furthermore, even if that standard wasn't, the court held it wasn't met, that doesn't result in suppression. Finally, I would do as a final argument, the court heard that a search warrant eventually happened in this case. They searched the house as well. That search warrant included language from the source of information about the gun sale. The state would argue that that information on its own, even if you sever out the drug and drug paraphernalia found on the Act 79 search, was sufficient for the search warrant, and that is another basis to hold in favor of the state. Thank you.
Ms. Landgraf?
Your Honor, could I just have 1 second to confer with my client?
You sure may. If you would like to go outside, we can just totally go off the record for a minute. If you want a little bit more privacy, I'm totally fine if you want to stay here though.
Okay, we'll just step outside.
Off the record momentarily.
I'm just gonna stand because I have back pain.
Ms. Burhow, we do have our 1:30, and maybe you too, Mr. Schmidt, Robert Heath, that's been asked to be moved slightly to a different day. So that one is off.
You said Robert Keith?
Yes, Heath.
Thank you.
Okay.
You're welcome.
Curious, does Brady ask you for a lot of advice about Cohen? You guys get to like share like stuff you have? Yeah,
I'm like,
honestly, it's incredible.
I'm just gonna send the court into the waiting room while we wait. Okay, Ms. Burhow?
Oh, sure.
Back on the record, same appearances as previously noted. Ms. Landgraf?
Thank you, Your Honor. The evidence was lacking for Act 79 search. There was no evidence that the probation agent was contacted either before or after the search, which is a requirement. Also, although there was testimony that he was on probation, there was no evidence on what he was on probation for. It must be a felony offense or under certain misdemeanor chapters. None of that was testified to. So I think the state's argument fails. And
well, that's easy to cure. It can be, he can motion right now to reopen. Court can say, yep, he can go and get it on. And that one's easy to cure. Anything else?
No.
All right. I'm going to guess you're going to ask the motion to reopen.
I could, but I'm actually confident he did testify it was felony drugs.
And I don't know at this time, Ms. Burhow is an amazing court reporter, but I don't get to have real time when I have somebody who is not in my courtroom. Usually I have real time. So I don't know. I knew, and I can just say, I know what Mr. Akana is on probation for. I'm the one that sentenced him and sent him to prison. So I'm well aware of that, but you may be confident, Mr. Schmidt, but I don't know. So if you would like to, if you are going to ask to reopen, I don't know, because that probably could have went right over my head because I know I sent him to prison. So
I'll just call the officer then if the court doesn't
all
remember
right.
either.
Deputy Mangan, you are still under oath. Please come forward. Just have a seat. Mr. Schmidt.
Prior to going to the Akana Kurkowski residence, did you call DOC?
I did not.
How did you confirm the supervision status?
During those checks that I testified to, one of those returns that we get when we run a check of somebody is a DOC return. The DOC return provides information on demographics of the probationer, as well as address, date of birth, those such things, as well as the offenses that they're on supervision for. The offenses that Mr. Akana was on supervision for were felony level drug offenses.
Okay, and that's also the same return that said where he lived?
Yes, his address is on that return as well.
Okay, that's all.
All right, any questions?
No.
You may step down. Thank you. Any further argument, Ms. Landgraf?
No further argument, Your Honor. I was provided with some of this additional information. Part of my motion was that I didn't have any information about why the Act 79 search was done. And I did get a report from the DA's office on Friday emailed to me. It was heavily redacted.
I'm going to guess that would be the information source. Source of information.
I actually don't have the source of information, and I don't think my client's entitled to that because that's not her accuser. That is Eddie's accuser. So I know that we're not entitled to that, but I did want to inform the court. Like I did get additional information on Friday, but
it was last minute. Yeah. Before this. So I understand. Okay. Any rebuttal?
No rebuttal. Just, I apologize for getting that to you last minute. I knew what the content of the information was, but I didn't know until last week there was a written version of it. So that's why I tried to get it to you as soon as I got it.
All right. Okay, well, I have heard the testimony of Deputy Mangan here today. And Ms. Landgraf, even though I was aware why Mr. Akana went to prison, I sentenced him. I still can't rely upon that, like you said, and unless it is verified through a source, or perhaps I could have taken judicial notice of that fact, but I didn't need to. Under case law, anyone can ask to have a suppression hearing reopened, even a day or so after the suppression hearing. The courts did allow Mr. Schmidt to continue to question Deputy Mangan. The court did receive a lot of information regarding that search and what led to the desire to perform that search. We are using a source of information. I guess not necessarily a confidential informant, or it's not with Ms. Kurkowski. It's a source of information. And here the source of information, as testified by Deputy Mangan, has proven to be reliable in the past, that there was a basis of knowledge of that source of information, personal knowledge, that individual was present at that time of the alleged sale of the firearm between Mr. Akana, Hawaiian Eddie, and this other guy, Nelson. There was much specificity as well as detail provided regarding that day, that time, that place, and who was there and what exactly happened and all of those things. And so when reviewing a source of information, the court has to look at the multiple factors to determine the totality of the circumstance here. And if, in that basis and in that review, the court does find that there is enough to find reasonable suspicion as it relates to any alleged crime that may have been committed, was committed, or is about to be committed. And in further, as it relates to an Act 79 issue, that in Act 79 is stated by Mr. Schmidt with U.S. Supreme Court cases, and then an older Wisconsin case as it relates to parolees, that there is such a reduction and lesser degree of constitutional rights as it relates to probationers. Therefore, that would give the ability for Deputy Mangan to be able to do a search. Mr. Akana stated he lived at that residence. Ms. Kurkowski stated that she lived at that residence. There was testimony from the deputy that that bedroom in some way marked and identified that it was Mr. Akana and Ms. Kurkowski's bedroom. So they did share that bedroom. Ms. Kurkowski did walk Deputy Mangan through the home to the bedroom in which the drug paraphernalia was visually seen by the law enforcement officer, which did give further ability to seek a search warrant, as there was a belief that with at least the drug paraphernalia that there could be a potential to have illegal substances in the home. Therefore, based upon all of that information, there was sufficient evidence to, there was enough reasonable suspicion to do an Act 79 based upon the information, and there was sufficient evidence included in the search warrant to have the search warrant granted. Therefore, the court is going to deny the motion for suppression. Anything further on the record?
Not from the state.
No, Your Honor.
Let's get a date and time.
We do have an offer that I believe is reasonable that I'll discuss with my client in more detail.
It's reasonable, so would you like to set something that could be a potential plea and sentencing? And I'm asking that right now just because my summer is so jam-packed with court cases. And if we set it for status, likely it's not going to be until fall.
Yes.
I could do, it's on an ADA week because again, this is a lot. I could do July 23rd at 10, and that's right after our CJCC meeting, Mr. Schmidt.
That should be fine.
Does that work for you, Ms. Landgraf?
So that's next week. So.
Otherwise, the next available date would be August 25th at 9:45.
Do you have a preference if you want to do it next week or do you want to do it in August? Yeah, my client's already scheduled to work next week. So if we could have that August 25th date.
August 25th at 9:45. All right. Well, actually, I'm not sure how long this would take, but could you do 9:30? Because I have an initial appearance on that date and time, but it's most likely going to go away from a deferred program.
Yes.
All right, so 9:30 on August 25th. So just block it that whole half an hour because then we have that competency hearing. All right, thank you. We will see you then. You can come up here and get your notice. Ms. Burhow, I'm going to log off and then log back on around.
What looked like a straightforward drug possession case took an unexpected turn when the defense challenged the legality of the entire traffic stop. Police testified that they pulled the defendant over because the rear window of her vehicle was blocked, making it difficult to see behind the car. During the stop, officers discovered that her driver's license was suspended. After arresting her, they searched the vehicle and found suspected narcotics. At first, it seemed like the prosecution had a strong case. But then, the defense focused on one critical issue. Did police actually have legal grounds to stop the vehicle in the first place? The defense argued that under Michigan law, a blocked rear window alone is not automatically a traffic violation if the vehicle has functioning side mirrors. During cross-examination, one of the officers admitted that, as far as he knew, the vehicle did have both side mirrors. That single answer changed everything. The judge questioned the prosecution, asking how there could be probable cause for the stop if the law required more than just an obstructed rear window. After hearing arguments from both sides, the judge concluded that the stop was not legally justified. Then came the ruling. The judge dismissed the case, explaining